Bring them in.
Yep.
Hello, Your Honor.
Hello, I'm just putting us on YouTube Live.
Bring them in.
Yes, ma'am.
Eric,
Yes.
we did file the amended complaint June 16th.
Okay.
Okay, when I record, we're gonna start recording. You can, if there's anything we need to put on the record preliminarily, after the introductions, we'll do that. I heard you talking about the amended complaint and whatnot. Going live. Ms. Clifton?
This is case number 18015-181NF, Surgical Center of Southfield, Tara Wilder versus State Farm et al.
Okay, can you appearance for the record?
Eric Stone appearing on behalf of Carol Wilder.
Good afternoon. Daniel Groves appearing on behalf of the Surgical Center of Southfield.
Good afternoon, Your Honor. Spencer Chauncey on behalf of defendant State Farm.
Good afternoon, Eric Doug, also appearing on behalf of plaintiff Wilder.
No, that. Was there something preliminarily? I know, Mr. Groves, you had made a statement before we called the case. Is there anything you want to put on the record preliminarily, or do you want to discuss those matters after the motion or during the course of the motion?
Your Honor, just that all parties, I'll confirm with all parties that Your Honor issued an order for my client to amend its complaint and add a Amerisure. And I was just saying that we did file that amended complaint on June 16th, and it was accepted by the Wayne County Circuit Court on June 16th of this year.
Okay, all right. Okay, thank you. Mr. Chauncey?
Yes, good afternoon, Your Honor. This is State Farm's motion for summary disposition as to claims against State Farm by Ms. Wilder and Surgical Center. The motion's brought under 500-31142, which provides an exception for the priority, indicating that the operator of a motor vehicle operated in the business of transporting passengers shall receive PIP benefits from the insurer of that motor vehicle. In this case, that's Amerisure. I don't think there's much dispute anymore, which is why the amended complaint was filed as to Amerisure. They were insuring the subject vehicle at the time of the subject accident. We were unable to prove that until co-defendant's owner finally showed up to a deposition, provided the certificate of no fault insurance, and showed that it didn't end until the day after the accident. So it was in full force and effect. I don't think there's much dispute at this point over that. I know Your Honor is very familiar with this case and that we had a lot of trouble getting that deposition to actually move forward. We filed the MSD as soon as possible after that.
Your Honor, may I respond?
Yes, Mr. Stone.
We filed the appropriate, so the plaintiff now is going to be dismissed, and we also have to bring in Amerisure. But we have a 1-year back problem because the order of priority was granted accordingly. So my client's not going to be punished if you grant this motion. The correct way to do this is have State Farm subrogate or go after the appropriate Amerisure, which we still don't know if they're covered. We just have a certificate. Remember, Amerisure didn't defend the case in the initial. They said we're not covering this case because there's no insurance. So all we have is a certificate saying it went 1 day past. Until that is disputed, my client's out in the wind, and they were a passenger in a motor vehicle. We filed the order of priority. So that's our argument with regard to this. Letting State Farm out at this point in time or any point in time would be detrimental to the No Fault Act, because that is the purpose of it. They were a passenger in a motor vehicle. That motor vehicle was uninsured. The next order of priority goes to State Farm, and that's where we're at.
Mr. Groves?
Your Honor, I would respectfully concur with Brother Counsel Eric Stone, and I would further say, defense counsel said in full force and effect. I would only dispute that other than that deposition where certificate, which was not certified, I understand the testimony, but the certificate itself was not verified from the insurer carrier. So I would not say that it's absolute beyond any doubt before this court that was in full force and effect. So with that being said, I concur with Mr. Stone that this is severely detrimental concerning the year back rule. If your honor was to consider granting this MSD, I would absolutely respectfully request that it's done without prejudice, because there are several reasons that it could come back to State Farm. It's just undetermined. Now, since your order back in June, Your Honor, we did amend and bring in Amerisure June. Now that it's the summons is good for 90 days, we haven't got a response back yet, right? So that's still kind of hanging up in the air. June, it's about 6 weeks later on the 90 days. I think it's premature to do an MSD and dismiss them out. And once Amerisure answers and is in and can be verified, then maybe then. Right now it's premature. But at a minimum, because of the year back rule and the detriment of the full enforce and effect, not just because of the certificate, but there may be other affirmative defenses that Amerisure may have that they haven't even presented to this court yet. So I would respectfully request that this be denied and maybe revisited after we get an answer from Amerisure. And that 90 days hasn't even expired yet. Now, I understand that brother counsel from defense said we file this as immediate as soon as possible, but all the facts aren't fleshed out yet to file it yet until the Wayne County summons of 90 days has expired and they get a default at that point in time. Thank you.
Mr. Stone?
And I guess I would have to add Amerisure now too to the case real quick. I don't know why we didn't talk about it when we did the prior motion. And we only did it for surgical center, but my clients, even if it is Amerisure, way down the road, who's going to pick up my client's medical bills in the meantime?
Right.
I mean, because so now we got a 1 year back. We found out 2 years later, we did everything we could do as a passenger in a motor vehicle. It's kind of a bad mess. And the only way to make everyone whole again is have State Farm pay and then subrogate against the insurance companies. They got 6 years to go after these people.
Right. Right. I think it's let Mr. Chauncey, I'll give you one more opportunity.
I was just going to say, Your Honor, the idea that Amerisure was never in this case isn't really accurate, considering the fact that Harvey Cruz, hired by Amerisure, was representing co-defendant Bright Transportation. They were aware of all these claims. That's why there's a claim file for Amerisure. That's why we were able to get the policy. They were working with us originally. You'll recall we had to do a motion to compel just to get the policy, and they weren't very forthright about any of that. They filed the motion to withdraw, claiming a conflict of interest. And then finally, another 10, 11 months down the road, we finally get co-defendant owner to come in and we get this certificate. He says it was handed to him. He testifies it was handed to him while he was purchasing the policy of insurance. And essentially, he had to pay up the rest of the policy later, but he was covered through February 10th. I understand the issue with the 1 year back rule. I would ask, and I wouldn't object to having this granted without prejudice as a State Farm, but State Farm's expended a great deal of resources on this. And we now have Amerisure that's going to be coming into the case now that Surgical Center has filed the amended complaint. And I believe the court's going to allow Mr. Stone to file the amended complaint for Amerisure also.
I am, but at this juncture, it's like I said, it's almost, I understand your position, but it's premature. Yes, I saw as the exhibit that we had the certificate of insurance, but was it valid? I don't know. And so if it's not a valid in full force and effect, then it still falls on State Farm. And State Farm, can, like I said, subrogate and get your attorney fees or whatever. But at this point in time, it's premature because we don't know what posture Amerisure is coming in because of the fact, they got a conflict of interest. The attorney left out the case, and and I'd be in a better position to support attorney fees for State Farm if in fact Amerisure is the one who should be responsible. But I think it's premature. I think there's still discovery pending. This is a matter where we saw a certificate of insurance, you know, and the insured is talking about, well, I had to go back and pay later, and we don't know what a measure is going to say. So, you know, in order for this to flow smoothly, and like I said, I understand that State Farm has incurred a lot of costs, but it may be necessary for State Farm to go back and get those costs against a measure. And if we have everybody in the same place at the same time, it's easier to do that. And, you know, you might have to enter a subrogation claim in this matter against a measure as well. But it's too premature because we don't know if in fact that policy that the certificate was presented for was in full force and effect. Because we know individuals, they get a policy, they just to get, you know, the insurance, to get the registration, and then they don't continue to make payments. So I think it's premature. So you know, in that.
Can I ask, Your Honor, could we hold off on ruling on the motion then until after Amerisher fires their answer for Surgical Center and Mr. Stone can get his complaint filed?
Well, the thing is, I can deny it without prejudice, because otherwise, you know, I don't want to hold it open. I'll deny it without prejudice, and you just keep it handy. If you just need to brush it off and refile, that's perfectly fine. But I think we need to determine from Amerisher, and Mr. Groves, you said you got a file from Amerisher, did you not?
I did not say I had a file. I'm saying we're waiting on their answer from, we filed our amended complaint with the court and we got the summons and we have served.
I thought maybe I misunderstood. I thought someone indicated that they did have a claim file from them.
There was an original claim file, Your Honor, and Harvey Cruz was representing Mr. Ali. And then Harvey Cruz dumped Mr. Ali after they rescinded the policy.
Okay.
So that's what happened. And if I may make a suggestion in this case, ultimately it's going to be either Amerisher or State Farm. Well, if you allow us to amend and Amerisher comes in and says it's them, then my client's still not whole again, because State Farm's going to say it's Amerisher and a 1-year back applies. So my suggestion is State Farm should bring in Amerisher right now and then go after Amerisher for attorney fees and costs for this fiasco they've created by dumping Mr. Ali in the beginning. Because that way we don't have multiple suits going on.
I think everybody needs to add a Amerisher. Mr. Chauncey, your client, and I would gladly, if it turns out that Amerisher is the culpable insurance carrier, I'll grant your fees, and we can do it all right here. So what I'll do is I'll deny the motion without prejudice, and I'll grant both State Farm and plaintiff Wilder to file an amended complaint, and what you file a cross claim of subrogation, right, Mr. Chauncey?
Correct. Or I can't recall. There's multiple Wilder suits, so we have filed a notice of non-party at fault as to Amerisher in either a related case, or I thought it was this case, but it must be the related case in Oakland County, which you've already been dismissed out of now. So I can do that in this matter as well.
Okay, and Mr. Stone, so I would need each of you, and Mr. Chauncey, you can place that in your order, that you know, deny without prejudice, and you're permitted to file a claim against. Are you going to file a claim or non-party? What are you going to do?
We've handled it as a notice of non-party at fault in the other ones. If it came down to it down the road, then it would be a subrogation action. But they're going to have already amended their complaint, and once they're in, we can just refile this MSD. It's kind of how I look at it.
Okay, so but you're going to file your non-party at fault, correct?
Yeah, but I'll file a notice of non-party at fault.
Okay, and Mr. Stone, you're going to file. We'll give you 7 days to file your complaint. Can you do that, Mr. Stone?
Yes, ma'am.
Okay.
Yes, Your Honor.
Okay.
My only other question, Your Honor, we've obviously gone past like track 4 in this case, and we went to case value.
I know, we're on track. We're on track 20.
Yeah, somewhere around there. So I'm assuming discovery is going to have to be reopened once Amerisher.
Yeah,
okay.
by all means. So what I'll do is, I'm gonna. Okay, so Mr. Stone, I'm giving you 7 days. Mr. Groves, yours was already filed. You're just waiting to see what's gonna ultimately end up with yours, right? You served.
That's correct. That's correct. Once the 90 days expires, I will be proactive in the default if they don't answer.
Okay. Well, let me put this out. I'll put this out, Mr. Stone. Like I said, I'll give you 7 days. And is it all right? Do you think if I gave you a 60-day summons that that'll work for you?
Yeah, no, we're working on it right now, Your Honor. I have my colleague in the room and we're already drafting complaints, so we're ready to go.
Okay, so what we'll do is I'm going to, and Kim is here, so she'll make a note that we'll give this a 60-day summons once we get your complaint. And I'll put this out. Let me give you a date.
So Spencer, you'll have yours filed?
Yeah, I can do the notice of non-party to file by tomorrow.
So are you gonna file a lawsuit against them or just file them?
I don't think it's necessary for us to file one currently because you guys are gonna have amended your complaint. We'll file the notice of non-party to file, which will be filed before they even respond with the answers to your guys' complaints. And then I think we can just proceed with this MSD again. I don't think it's necessary for us to file that currently when we can just file a separate subrogation action afterwards if necessary.
Okay.
Okay.
Oh, September, October.
If something changes and Janetta wants to go a different route, I'll email you guys.
Okay.
Spencer, may I say on the record, the only thing I agree with you is the block M behind your head on the wall.
Okay. Go Blue.
Go Blue.
Go Blue.
If we weren't on YouTube Live, I put up my Michigan background too. But
Yeah, I know, Your Honor.
okay. What about let's say October 21st at 11:30 for continued final pretrial conference. Is that okay?
Yes, for Southfield Surgical Center, yes.
Mr. Stone?
Yes, the date again, October?
21st at 11:30.
We
Mr.
got it.
Johnson?
Yep.
Yes, that'll work. I think today was noted to be the settlement conference.
Yeah, yes.
Okay.
It will just continue it because we took care of the business that we needed to take care of now.
And Dan, if someone answers on behalf of Mayor Scher, let me know who I can just give them the complaint to expedite that also.
Very well.
So we get the same attorney, so, okay. Thank you, Your Honor. You have a great day.
Just
Thank
for clarity, Your Honor, the order you just need denied without prejudice, and then plaintiff Wilder has 7 days to file amended complaint.
Yes.
Okay.
Anything else, gentlemen?
No, Your Honor. Thank you.
Thank you, Your Honor.
Okay, thank you all.
Thank you.